Welcome to the Deep Dive. Today, we're doing something a bit different. We're really getting into a core topic in equity and trusts, formalities. How trusts are properly created and how you transfer interests under them.
Exactly. And this deep dive is specifically designed for you, the learner. We want to help you get a solid handle on these crucial concepts efficiently and hopefully memorably.
Yeah, and we should mention, this is all based on the fantastic learning resources made available to students by the University of London. So a big thank you to them for providing such comprehensive materials.
Definitely. And just a quick reminder for everyone listening, this is purely for educational purposes. It's about helping you understand the principles and get ready for your studies.
Right. So our mission today is basically to unpack the rules around creating trusts, especially, when land or a will is involved, and also how interest under existing trusts get moved around.
We'll break down the legislation, look at the key cases, and really try to give you a clear picture. We'll also flag what you really need to focus on for exams.
Okay, let's dive in then. Where do we start? Maybe an overview.
Good idea. So broadly, we're looking at three main areas today. First, declaring trusts of land. That's got specific rules.
Okay.
Second, trusts made in wills, testamentary trusts. Again, specific requirements there.
Right.
And third, transferring interests that already exist under a trust. This third one applies whether the trust holds land, shares, whatever.
Got it. And is it true that for creating trusts of things other than land, like, say, shares or money, there aren't really any special formalities?
Generally speaking, yes. For creating trusts of personal property, you don't usually need writing. But remember that transferring an existing interest under any trust, that's where formalities often kick back in.
Okay, that's a useful distinction. So let's start with the first one, declaring trusts of land. That brings us to the Law of Property Act 1925, Section 53, 1 main.
Exactly. Section 53, subsection 1, paragraph B, or 531B for short. The absolute core idea here is that any declaration of trust involving land needs to be manifested and proved by some writing signed by some person who is able to declare such trust.
Manifested and proved.
Yeah.
Okay. Does that mean the writing itself creates the trust?
Not quite. That phrasing is deliberate. It actually comes from the old Statute of Frauds from 1677. The point wasn't that the writing is the declaration, but that you need written evidence that a declaration happened.
Ah, the Statute of Frauds. Sounds like it was trying to stop something specific. Fraud, obviously, but what kind?
Precisely. The big worry back then was people falsely claiming, hey, that landowner told me he was holding his land on trust for me. The statute aimed to prevent those kinds of bogus claims against landowners.
Right, so protecting the landowner from false accusations. Less about stopping a landowner denying a real trust they'd made.
That seems to be the original emphasis, yes. It was about needing proof to bring a claim against someone else.
Okay, so it's about evidence. When does this written evidence need to appear? Does it have to be right when I say, I hold this land on trust?
No, not necessarily. Because the rule says manifested and proved, the writing can come later. It just needs to exist at some point to prove that an earlier declaration, maybe even an oral one, actually took place.
Is there a case that shows that?
Yeah, the famous case Gissing v. Gissing is often cited for this. Later written documents were accepted as proof of an earlier understanding or declaration about the property ownership. So the writing is evidence of a past event.
So if I declare a trust of my house for my brother verbally, that declaration is technically valid from that moment. But if we fall out later, he'd struggle to enforce it without something signed by me.
That's exactly it. Section 531B is seen as a rule of evidence. The oral trust is valid, in theory, but unenforceable in court without that signed writing. It's sometimes described as valid but unenforceable, though that phrase can be a bit tricky. The point is, without the proof, the court can't act on it.
Okay. But what if relying on the lack of writing is itself fraudulent? If the person knows they agreed to be a trustee.
Now you're onto the big exception. Equity has this core principle. It won't let a statute designed to prevent fraud be used as an instrument of fraud.
Makes sense.
And the key case here is Rochefoucauld v. Bousted. It's a landmark. Essentially, land was transferred to someone, supposedly on trust, but there was no writing as required. Later, the person denied the trust, relying on the statute.
And the court said?
The court said no. Allowing the defendant to deny the trust and keep the land, just because of the lack of writing, would be a fraud in itself. So they allowed oral evidence to prove the trust existed.
So the need for writing under the statute gets overridden to prevent a worse outcome, actual fraud.
Precisely. But then there's a bit of a debate, an academic one mostly, about what kind of trust is being enforced in a Rochefoucauld situation.
Oh, express or constructive.
Exactly. The court in Rochefoucauld itself seemed to think it was enforcing the original express trust, now proven by oral evidence. But some later cases, in Ober dicta comments made in passing, like Bannister v. Bannister and Paragon Finance v. Thackeray, suggested it might be better seen as a constructive trust.
Why does that distinction matter?
Well, it links to how we see Section 5331B. If it's just about evidence, then enforcing the proven oral express trust makes sense. But if the lack of writing means no valid express trust ever arose, then maybe the court imposes a constructive trust because of the fraudulent behavior.
Okay, I see the nuance. And this ties into the other part of Section 53, subsection 2, doesn't it?
Yeah.
A bit about resulting in constructive trusts.
You've got it. Section 532 explicitly says that the writing requirements in Section 53 do not apply to the creation or operation of resulting, implied, or constructive trusts.
Why not?
Because these trusts arise by operation of law, based on circumstances and conduct, not usually based on proving someone declared a trust in the formal sense. Think of resulting trusts based on purchase money contributions or...
The family home cases, like Pettit, Gissing, Stack v. Dowden, Jones v. Kernot.
Exactly those. Cases you'll look at in property law often involve common intention constructive trusts. The court finds a trust based on the parties' shared understanding and behavior regarding the home, even without that signed writing under 53(1)(b. They arise from conduct, not formal declaration.
Right, okay. That covers land trusts pretty well. What about testamentary trusts, the ones in wills? Section 9 of the Wills Act, 1837, is the key here.
Yes, Section 9 of the Wills Act, 1837, is vital. It sets out very strict rules for making a valid will.
Can you run through them quickly?
Sure. It has to be in writing. It must be signed by the testator, the person making the will, or by someone else in their presence and by their direction. The testator must intend by their signature to give effect to the will.
Okay.
And crucially, the signature must be made or acknowledged by the testator in the presence of two or more witnesses present at the same time.
Two witnesses both there together.
Yes. And then each witness must attest and sign the will or acknowledge their signature in the presence of the testator. It's quite a formal process.
And if you miss one of those steps,
Then the will is generally invalid. And if the will is invalid, any trust contained within it is also invalid. It's a strict rule. And remember, will includes codicils, amendments, and other testamentary dispositions too.
now the materials mention a similarity to Section 531C, which we'll get to, but also that courts sometimes treat Section 9 differently, almost like an evidence rule, in secret trust cases.
That's a really important point for later, yes.
Yeah.
On the face of it, Section 9 looks like a rule of validity comply, or it's void. But in the very specific context of secret trusts, which we'll cover in another topic, courts have sometimes enforced trusts even when they weren't fully compliant with Section 9's witnessing rules, by admitting other evidence of the testator's intention to create a trust, effectively treating Section 9, more like Section 531B, as something that can potentially be sidestepped to prevent fraud. But, and this is crucial, outside of secret trusts, Section 9 is absolutely about validity. No compliance, no valid will, no valid testamentary trust.
Got it. And one last thing on wills. They don't actually do anything until the person dies, right?
Absolutely correct. A will is completely ambulatory, as they say. It has no legal effect at all until the testator's death. They can change it, revoke it, tear it up any time before then.
Okay, clear. So land trusts, testamentary trusts. Now the third piece, transferring an interest that already exists under a trust.
Yeah.
Section 53, 1C of the LPA 1925.
Yes. Section 53, subsection 1, paragraph C. And this one is different again. It's a true formality rule. It states, and the wording is key, a disposition of an equitable interest or trust subsisting at the time of the disposition must be in writing, signed by the person disposing of the same, or by his agent thereunto lawfully authorized in writing, or by will.
Must be in writing. That sounds much stronger than manifested and proved.
It is much stronger. This isn't about providing evidence later. The act of disposing, transferring the existing equitable interest itself has to be done in signed writing from the outset.
And if it's not, if I just tell my trustee to hold my interest for someone else now,
Then, according to the House of Lords in Gray v. IRC, that oral disposition is void, completely ineffective from the beginning. No writing, no valid transfer of the equitable interest. It's a critical difference from 531B.
so what counts as a disposition then? Gray must have defined that.
It did, and the courts have taken quite a broad view. The classic Gray example is where a beneficiary tells their trustees, "Stop holding my interest for me, hold it for my grandchildren instead." That's a disposition needing writing.
Okay. What else?
Well, Vanderbilt v. IRC involved a direction to the trustee to transfer the legal title to shares to a third party, intending the equitable interest to go with it. That was also considered potentially within the scope, although the outcome there was different for other reasons we'll touch on.
Right. So directing the trustees either about the equitable interest directly or about the legal title with the intention the equitable interest follows.
Yes. Also, importantly, if a beneficiary declares themselves a trustee of their own equitable interest for someone else creating a subtrust, cases like Nelson v. Greening and Sykes and the recent LA Micro Group case confirm this needs writing under 531.
Wow. Even creating a subtrust counts as disposing of the original interest.
It seems so, yes. The view is that the original beneficiary is dropping out of the picture in a way. Also, if the trustee declares a new trust for a third party, but does so with the original beneficiary's consent that was looked at in Ria Vandervel's trusts, number 2.
It seems to cover a lot of ground. What about contracts? If I contract to sell my beneficial interest?
Yes, that's generally caught too. A contract to assign an equitable interest falls under 531C. Think Autred v. IRC and Neville v. Wilson. Even surrendering your interest back to the trust, IRC v. Buchanan, or disclaiming it saying you never wanted it in the first place, Paradise Motors, have been held to be dispositions requiring writing.
Okay, it's broad and it's strict. Why? What's the policy behind Section 531C? Is it just fraud prevention again?
Fraud prevention is part of it, yes, tracing back to the statute of frauds. But the specific rationale emphasized in Vanderbilt v. IRC for 531C is really about protecting the trustees.
Protecting the trustees. How so?
Imagine you're a trustee, the beneficiary, Alice, has the interest. Then someone, Bob, turns up and says, Alice transferred her interest to me verbally last week, pay me now. If there's no signed writing from Alice, how does the trustee know Bob is telling the truth?
They don't, really. They could pay Bob, and then Alice could say, I never did that, and sue the trustee for paying the wrong person.
Exactly. The writing requirement gives the trustees certainty. They can say, show me the signed document from Alice. It prevents hidden oral transactions and protects trustees from claims by alleged assignees and potential liability for breach of trust if they pay out incorrectly. It creates a clear paper trail.
That makes a lot of sense. Now, you mentioned Vanderbilt earlier. The learning materials hint at a possible tension or inconsistency between Gray and Vanderbilt. What's that about?
Right. This is a subtle but interesting point. In Gray, the beneficiary orally told the trustees, hold for my grandkids. That needed writing under 531C. But in Vanderbilt, the beneficiary orally told the trustees, transfer the legal shares outright to the Royal College of Surgeons, intending the beneficial interest to go to, effectively ending the trust over those shares. The House of Lords said that transaction did not require writing under 531C.
Why the difference? In both cases, the beneficiary told the trustees what to do.
The reasoning in Vanderbilt was that because the legal title was also moving, and the intention was to pass the absolute interest, both legal and equitable, and extinguish the trust relationship regarding those shares, Section 531C wasn't designed for that situation. Lord Upjohn famously said the section is aimed at cases where the legal title remains separated from the equitable interest. The purpose protecting trustees managing an ongoing trust wasn't engaged if the trust itself was collapsing.
So if you move the legal title along with the equitable interest, intending to end the trust over that asset, 531C might not apply.
That's the Vanderbilt principle. But it does seem slightly odd compared to Gray. In both cases, the trustees got instructions directly from the beneficiary. Why was writing essential for the trustees' protection in Gray, but not in Vanderbilt? It's a point people debate. Does the rationale of protecting trustees fully explain the difference in outcomes?
Yeah, that's definitely something to think about. Okay, shifting gears slightly, let's talk exam preparation. For students listening, what are the absolute must-knows, the key focus areas for this topic?
Number 1, absolutely fundamental. Nail the distinction between Section 531B and Section 531C. You have to know that B is about evidence for land trust declarations, and C is about the formality or validity of dispositions of existing equitable interests. One is proof, the other is the act itself.
Okay, evidence versus validity. Got it. What else?
Memorize the wording. Seriously. Know the key phrases from 531B, 5B31C, and Section 9 of the Wills Act. Examiners like to see the actual statutory language used correctly.
Right. And the cases.
Absolutely. Know the key facts and, more importantly, the legal principle or ratio decidendi of the main cases. Rochefoucauld, Gissing, Gray, Autred, Vandervelde, Nelson v. Greening, and Sykes. Don't just name drop. Understand why they're important.
Explain the why behind the rules, too.
Yes, understand the rationale, fraud prevention, protecting trustees. It helps you apply the rules logically, and know the exceptions inside out. The Rushikow fraud principle for land, the Section 532 exclusion for resulting constructive trusts, and the Vanderbilt exception for 531C.
What about those reform ideas mentioned in the sample feedback?
It's good to be aware of them. Things like potentially abolishing 531B because evidence law has moved on, or maybe strengthening 531C by adding a requirement to notify the trustees. It shows deeper thinking.
And finally, practice, practice, practice.
You got it. The best way to embed this is to apply it. Work through problem questions. Ask yourself, is this an attempt to declare a trust of land or dispose of an existing interest, 531C? Is it a will, Section 9? Is there an exception? For instance, what if someone orally declares they hold their existing life interest on trust for someone else? Is that a disposition needing writing under 531? Think about Grange v. Wilberforce, Nelson. What about a specifically enforceable contract to assign? Autred, Neville. Compare scenarios like Gray and Vanderbilt. Applying the law to facts is key for exams.
Okay, that's a great checklist. So just to quickly recap then, we've covered the key formalities for creating land trusts, the very specific rules for wills and testamentary trust, and those strict requirements under Section 531C for transferring existing equitable interests.
And remember that crucial difference. 531B for land is about proving the trust with written evidence, while 531C for dispositions generally demands the transfer itself be in writing to be valid at all.
And the cases Rochefoucauld, Gray, Vanderbilt, they aren't just names. They really illustrate how these principles work, the problems they solve, and sometimes the tricky areas. Understanding them is vital.
Absolutely. Knowing the stories behind the rules makes them stick.
So here's a final thought for you, the listener, to take away and perhaps mull over. We've been talking about rules, some of which are centuries old, designed to prevent fraud in their time. But think about it. In our modern context, with different ways of communicating and recording things, do these specific writing requirements still effectively prevent fraud? Or do they sometimes create unnecessary hurdles, complexities, maybe even new kinds of injustice?
It's a live question. Do these formalities strike the right balance today? That's something lawyers and academics continue to debate, and it shapes how the law might evolve.
Indeed. Well, this deep dive should give you a really solid foundation. We definitely encourage you to go back to the core readings, look closely at those essential cases, and maybe explore some further reading too.
Keep asking questions, keep digging deeper. Equity and trust is a fascinating area, and understanding these formalities is a key step.